While you'll never see a rich person go through probate in Georgia, let's talk about that. Have you ever wondered why you never see wealthy families stuck in probate court for like months on end fighting over their parents' estate? Well, now I'm not going to say that every rich person out there doesn't get stuck through going probate. I mean, after all, who cannot forget Anna Nicole Smith and J. Howard Marshall? And technically that was a trust. But I have worked with dozens of families going through probate here in Georgia as a real estate agent who specializes in probate. And I notice there isn't a lot of estate planning for families. Most often I see people without wills, without taking title correctly on their deed. We have a video about that. Without money to pay for the mortgage and without a plan. But here's the thing. The rich aren't just avoiding probate because they have an expensive attorney or complicated trust. What they're actually doing is way simpler than you think, and I'm going to show you exactly how they skip the probate process, which is a nightmare, or it can be. Since getting certified in the probate process, I have helped families navigate, and I've seen what works, and I see what causes absolute headaches. So let's dive into these 3 strategies wealthy families use to avoid probate altogether, and how you can use them too. First up, the trust strategy. Trust can cause a little bit of money up front, but when you look at the benefits in the long run, sometimes it's worth it. So let's talk about this strategy, which is creating a trust. And there's several ways to create a trust, so always go seek out an attorney. I am not an attorney, but I know what you might be thinking. You might be thinking, Tanya, trusts are for rich people. And that's exactly what most people believe. But here is what's really happening. A trust isn't about how much money you have. It's about control and privacy. When someone dies with just a will, that becomes public record. And anyone can walk into the courthouse and see exactly what you owned, who's getting what, and how much it's all worth. Therefore, wealthy families use trust because they want to keep their business private. They don't want neighbors or ex-spouses or predatory investors to know their financial details. And here's the key to trust. It has to be funded. That means you actually have to transfer your deed of your home into the trust name, your bank accounts into the trust name, investments into the trust, and you have to do this while you're still alive. I see people make this mistake all the time. They create a trust, they pay for the attorney, and they never fund it. If you leave one asset out of that trust and you don't name a beneficiary, guess what? You're going through probate anyways. Therefore, if you're just going to do a trust, you got to fund it properly. And that's where working with someone who understands this process, whether it's a real estate planning attorney or an elder care attorney, becomes critical. Now, here's what I love about the trust. Even if someone tries to sue the estate, the trustee can still do their job as a trustee. Whereas if you just have a will and you're going through probate, that lawsuit can bring everything to a grinding halt that nobody really wants. Next up, let's talk about how we take title appropriately. And specifically, let's talk about joint tenancy with rights of survivorship. So joint tenancy with rights of survivorship, this is mostly used by married couples here in Georgia. And here's how it works. Even when you own a property as joint tenants, each person owns equal shares of that property. So if there are 2 people, then they actually own 50% each. But, and this is critical, you need the phrase with rights of survivorship on your deed. If you have joint tenancy and you don't see that rights of survivorship verbiage, the spouse doesn't automatically inherit and you're stuck in probate. Therefore, the first thing that you should do is pull out your deed and check. Do you see the words rights of survivorship on it? Now, if your house was purchased back in the 60s, 70s, 80s, maybe even 90s, maybe even as recent as now, you might not have that language on there. It really depends on the closing attorney and how they set up the deed. And because this is relatively a newer concept to Georgia, sometimes old habits die hard and you have the attorney forgetting to do joint tenants with rights of survivorship. Here's the good news. It's such an easy fix. You can go to a real estate attorney, and for not a whole lot of money, I mean, like maybe a couple $100, they can go in there and add that language to your deed. Now, if you're a single person, I want to caution you. Don't just add your child to the deed as joint tenants, thinking you're going to help them out. This is not a good idea, and there is a better way. If you do this, there could be major tax implications for the child after you die. I did a whole video on that. It's called Step Up in Basis and Carryover Basis when it comes to the value of the house and what the kid inherits. And so go watch that video, but here's a shorter version of what that video is about. There are better ways to transfer that property to protect your child from the huge tax burden, which brings me to the transfer upon death deed. Now, I'm going to go through this deed so you understand the purpose of this deed. And at the end of going through this little section, I want you to listen to what I recently heard about this deed, because there should be caution on this one as well. And that's why seeking out an attorney is critical. So let's dive into speaking a better way if you're single, if you want your children to avoid probate. And that would be pretty new to Georgia, the transfer upon death deed. I mean, it just became available as late as July of 2024. This I thought was going to be a game changer because it allows you to name a beneficiary on your property while you're still alive. You hold on to the title. You still control everything. But when you pass away, the property can get transferred into the beneficiary without going through the probate process. But here's the catch on this one. It's not a set it and forget it kind of deed. Your beneficiary has exactly 9 months to go to the courthouse and claim that deed. They wait 9 months and 1 day, that property's going to go through probate. So you can't sit around on your laurels with this one. If your beneficiary is on top of things and they handle it within that 9 months window, it's one of the simplest ways to avoid probate in Georgia. I did do a deep dive video on this transfer upon death deed. It does not come with the warning I'm getting ready to talk to you about. So go watch it and remember this warning. I was talking to an elder care attorney because I had somebody who wanted to do one of these transfer upon death deeds to protect her children. And he told me that title companies were having problems with this kind of deed, meaning that after someone passes away and the beneficiary goes and puts it in their name and they get ready to sell the house, there's title insurance that the buyer's going to want to buy. And if there's a loan that the loan's going to want to also buy to protect the buyer against any claims that might be against the house, because that stuff travels with the property if it's not cleared up before you pass on title from one person to another. And they don't like how the Georgia law is written up. It might not be as concise as it should be. And so now we're having some title companies not give title insurance on these deeds. So that could be trouble down the road. We will definitely keep an eyeball on this transfer upon death deed. So there you have it. It's 3 strategies that wealthy families can avoid probate, or any family for that matter: trust, joint tenancy with rights to survivorship, and that transfer upon death deeds. But here's what I really want you to understand. This isn't about being rich. It's about being intentional. And most wealthy families tend to plan ahead because they don't want to be in probate because it's so public and time consuming and can tear families apart. I've seen siblings fight over property and the entire process come to a grinding halt. Therefore, if you want to bless your family and not burden them, you've got to do some pre-planning now. And listen, if you're not sure how your deed is currently held, go to the courthouse and ask them to pull up your deed to take a peek. If you need help setting up a transfer upon death deed or creating a trust, I can point you to some professionals who specialize in this. They're attorneys who can help you out. If you do find yourself in the middle of probate right now because there wasn't any pre-planning, I'm sorry. And if there's real estate involved, please reach out to me because I specialize in probate. Not every real estate agent does. And I know how to navigate those tricky parts when it comes to selling estate property. All my contact information is below, and I hope you found this video helpful. We have other videos out there, so don't forget to subscribe. Click that bell notification so you know when we drop the next video. And hopefully this can help you protect your legacy and avoid the probate process altogether. Until next time, bye.